Three siblings inherit an agricultural land from their father. One sibling decides to sell his share to an outsider. Who gets the first opportunity to buy? The outsider or the other siblings? The Supreme Court has now given a clear answer. Under certain conditions, the other class 1 heirs must get the preference. But this right applies only to a specific category of inherited property. Here is exactly when you can claim it. In the case of Mahinder and Others versus Puran Singh, the father died without leaving a will. His children inherited an agricultural land as class 1 heirs. Some siblings decided to sell their shares to an outsider. But another sibling, Puran Singh, approached the court and claimed, before you sell the inherited share to an outsider, I have the preferential right to purchase it under Section 22 of the Hindu Succession Act. Importantly, Puran Singh asserted this right before the sale deed was executed. So what exactly did the Supreme Court decide? The court held that Section 22 of the Hindu Succession Act applies to agricultural land also. This means that when a Hindu dies without a will and the property is inherited by two or more of the class 1 heirs, one heir cannot ignore the preferential purchases right of the other class 1 heirs while proposing to sell the inherited share to an outsider. Class 1 heirs are basically the immediate family of the deceased, that is his wife, his children, a son or a daughter. So in this example, suppose a farmland is inherited by two sons and one daughter. If one son wants to sell his inherited share to an outsider, the other son and daughter may claim the first opportunity to purchase it. The purpose is to keep the inherited family property within the family as far as possible. But here is one more important clarification. This is not a general right over every agricultural land sale. Section 22 will ordinarily apply only when, first, the original owner died without leaving a will. Secondly, the property devolved upon two or more class 1 heirs. Third, one such heir proposes to transfer the inherited interest. And fourth, another class 1 heir wants to purchase that interest. Merely being brothers and sisters is not sufficient. If siblings purchased agricultural land jointly using their own money, Section 22 does not apply merely because they are related. Similarly, unrelated, co-owner, tenant, or distant relatives cannot claim the right under Section 22. This is a preferential right to purchase, not a right to block the sale or permanently acquire the land cheaply. The practical lesson is, before selling the inherited farmland to an outsider, identify all the class 1 heirs and, as a practical safeguard, make a written offer and document their acceptance or refusal. If you are the co-heir who wants to purchase the share, assert your right before the transaction is completed. Delay can seriously affect your remedy. Share this video with every family owning an inherited farmland, because one sale deed executed without proper legal advice can result in years of litigation.